the equity within their homes and land. I think of it as a glass box where you can see a a pile of money, but you can't access it. So the center works to resolve the heirs property issues and provide legal legal support for clearing titles. I believe maybe that my staff is ready. I think I just got a text. Are y'all ready? And it seems that instead of a PowerPoint, we're going to start with a video that the great folks at Fort Valley and UGA, Cooperative Extension, and also the center pulled together to sort of show you how common and some of what the issues are within families. So with that, I will turn it over to Libby.
Hello, and welcome on behalf of your Preserving Your Family Heritage team. Join us as we present The Aftermath. The setting is a family that has recently laid their loved one to rest. The family must now begin the business of probating their loved one's will. The family consists of 3 living adult children and 1 widow of a deceased child, and lastly, the brother of the deceased, Uncle Sam. Join us as the family learns the ins and outs of the probate process and how to proceed in fulfilling their loved one's last wishes. Let's drop in on our family as they have their initial meeting with an attorney.
Hi, how's everybody doing? So glad y'all could make it.
Hey, Bernice, guys.
Hey,
Yeah.
Bernice, what you been up to?
Not much.
Bernice,
Mhm.
Brian, of course. We were talking before you came on, and we just want to know, who is this person? Who is this lawyer we're meeting with? Nobody knows her, and now the family's meeting with her like this.
Brian, she's my attorney, okay? And she's just here to help us answer try to figure out this will, okay?
Look, I don't know if I'm comfortable with an attorney. I mean, she could be messing with Dad's property. We don't really know her. I mean, she could try to take something. I don't know.
Yeah, and I mean, ever since Bob died, I mean, y'all know your brother Bob, my husband. Ever since he died, I mean, he was so upset that y'all's dad's will would invite people to take the property. So I don't think that he would be comfortable with this. And I don't really want to do anything against his wishes since he's dead.
Just calm down, everybody. She's just here to answer a few questions for now, okay? We'll take this one step at a time.
Hey, everybody, how are y'all doing?
Hi, Miss
Hi,
Hey,
Miss
Miss Strickland, how are you?
I'm so glad that y'all could all make it because we're going to talk about your dad's will today and the probate process. And hopefully I can answer any questions y'all might have.
Ms. Strickland, I know today we're supposed to just, like I said, we're not making any decisions today or anything. And we're just supposed to, answer a few questions. But when are we actually going to get an opportunity to see and read the will?
Yeah, I agree with Brian. I mean, how do we know what each of us has? I mean, I never got to see the will because Dad hid it somewhere.
Well, Uncle Sam found it, remember? Where was it again now?
Who does this? Who actually hides a will in the freezer?
The freezer.
Freezer.
Well, that may sound kind of strange, putting the will in the freezer, but it really wasn't that bad of an idea. He was probably thinking that might be the safest place for it in case there was a fire or something, because you do want to definitely keep documents like that, like wills, in a safe, fireproof place. Also, where the family or the executor can find it easily, though.
Miss Strickland, can I ask a question? What is an executor? I mean, are one of us or all of us, whatever that is?
Well, the executor is the person that has been named in the will to oversee the decedent's estate, and the decedent is the deceased person. So your dad chose Bernice to be the executor of his estate.
Bernice? Wait, I'm the oldest living son that's left. and we all got to divide this up amongst everybody. Why can't we all be executors? That way everything is even, fair across the board, Ms. Strickland?
Well, when someone is choosing an executor, they're looking for somebody who is trustworthy and really responsible and organized, because there may be bills to pay from the estate, and then there may be money that needs to be distributed to the beneficiaries.
Right. And Brian, let's face it, we know you're not the most organized person in the family. You don't even know where you left your keys half the time.
Contrary to your belief, that's your opinion. But moving on, what's going to happen with the property if this is the case?
Well, your dad left the property to all of his children, but by doing that, he created what's called heirs property. Heirs property is whenever more than one person, or two or more people really, own a piece of property together.
So what about Bob? I mean, Bob, he was an heir. He's my deceased husband and their brother. Like, does that mean that me and my kids don't get anything because we're not children of the deceased?
Well, sometimes the property passes from the deceased child to their spouse and their children, or it can pass to their siblings as co-owners of the property. But since the will said that the property is divided per stirpes, Bob's interest in the property is going to actually pass to you and your children together. But if it didn't say that, then it would actually pass to the siblings as co-owners.
Well, what about the guy that showed up at the funeral that came up to us talking about he's dad's son? I mean, nobody knows him. We may have had some speculation, but nothing was proven. We don't even know if that's really his dad's kid. Okay, he kind of looks like us a little bit, but
You look like me.
I'm just saying, does he get to have anything that's left for us?
Well, since the will says that the property goes to all of his children, that includes any children born out of wedlock, if they were legitimate.
So now we have to share with that guy too?
Well, who's gonna pay the taxes?
And I was thinking about a vacation spot, like a second home.
And y'all know there's some timber out there. I mean, what happens with that?
Okay, well, so when more than one person owns property together, they're called tenants in common. And they have all the same rights and responsibilities that come with property ownership. So everyone needs to agree on what's done with the property.
Even the outside child?
Well, look, it looks like we know we need to do our wills, but maybe we should just kind of figure out what we're gonna do with this heirs property first.
I agree.
I told Bob he should have never written his will. He has made it any easier for you guys. He should have just not worried about it. Say the heck with a will.
Really, everyone needs an estate plan so that your family knows what your wishes are when you pass away. I know your dad was really trying to do the right thing by writing this will, but there are definitely better ways to leave property than leaving it to several people.
Come on, let's face it, you guys. Dad would have wanted us to make a plan, and that's all a will is, just like he had a plan.
And you can go ahead and write a will, even if you are an heirs property owner. That, I think that makes it even more important to get your will done.
Look, I agree with Unc. I mean, hey, I don't have a lawyer. I don't have much anyway. I'm not sure if I'm even going to do a will.
Yeah, I mean, I agree with Brian. I think wills are important, but let's face it, I'm too young now. And if I write one, I'm definitely going to die sooner. I mean, y'all know how that works. That's just the way it goes.
Well, you're really never too young to have an estate plan. And actually here in Georgia, you only have to be 14 to write a will. So it would help your family to know your wishes whenever you pass away. And I promise it's not going to make you die any sooner.
So say I did want to do a will and whatever, what information am I supposed to give an attorney? Because I don't want to give them too much information about everything that I have, and then all of a sudden I don't have anything.
Well, you certainly want an attorney that, you know, you're comfortable with and that is trustworthy. At our center, we would ask for information about the property you own, such as real property, bank accounts, retirement plans, and personal property that you might want to, you know, leave to somebody specific. And then, of course, we'd want information about your family and friends that you want to mention in your will.
Well, you know, I talked to Bob and we went round and round, and I just said, I'm just gonna write down what I want and send it to myself. Isn't that the same thing?
Well, did you have two witnesses when you signed the will?
Yeah. No, I did not.
Unfortunately, that does not constitute a legal will then. Sorry.
Let's face it, we do need to do our wills. Because a will is just simply a plan, you guys. And Dad had a plan. He would have wanted us to have a plan too, just like he did.
So the good news is you don't yet have to visit the Georgia Heirs Property Law Center for more information. You're about to get more information in this presentation. And now Libby, our amazing paralegal, will launch our PowerPoint. And I know that this is a detailed and confusing subject, but we're here to provide some clarity. And as soon as we get the PowerPoint up, then I'll pass the baton off to Gentry. And we do want to support y'all's questions. So if you have questions, feel free to put them in the chat. And then we will have moments throughout the presentation for questions also. With that, Gentry, it's all on you.
All right, I'll extend my own welcomes. Thanks so much for joining us today. Let's get going. This is our standard disclaimer. This information is educational. It does not constitute legal advice. There are no continuing legal education hours. And I'd like to remind y'all that when you're asking questions, to ask general questions. We cannot answer questions that are personalized and about your own situation. Oh, that's on this slide. There will be pauses throughout the presentation for you to ask questions, and we will present questions that have been submitted through the chat. So just a quick reminder, we covered this in a previous presentation, but what is heirs property? Heirs property is home or land that's been passed down from generation to generation in such a way that multiple people own it together. And so, okay. The Heirs Property Law Center is a not-for-profit law firm that specializes in, sorry, Skipper usually do these slides. We specialize in education and direct legal services to clear title and prevent heirs property through the creation of estate plans. Our mission is to build generational wealth, economic value, and community stability by securing and preserving property rights. We have attorneys, support staff, and a network of pro bono volunteers and grassroots organizational partners to help us succeed in this mission. So the roadmap for today, Delene's going to talk about what is estate planning. I'm going to go into a little bit more detail about last wills and testaments. We'll take a pause for questions. Delene's going to talk about what happens when someone dies with or without a will. I'm going to talk about preventing heirs property through estate planning. We'll pause again for questions, and then we'll go over what decisions you need to make before an attorney can prepare your estate plan. And then we'll do a wrap up and time for some more questions. So Delene, I'm going to pass it off to you here.
Great. Thank you, everybody. So let's get started. We're going to dive in. What is estate planning? Essentially, estate planning is the process of anticipating and planning for what will happen to your assets when you pass away, or if you become incapacitated. So you're going to be asking yourself questions like, how will I hold title to my property or my house while I'm alive? Who do I want to have inherit my assets, whether it's real property or whether it's a car or jewelry or other things like that. An estate plan also includes deciding who will make healthcare decisions for you if you become incapacitated or unable to make them for yourself. And another component of that is who will manage your assets if you become incapacitated. So the complete estate plan has three components: the advance directive for healthcare, the financial power of attorney, and the last will and testament. And in our previous workshop with Fort Valley, we talked a little bit more about the advance directive for healthcare and the financial power of attorney. So I would encourage anybody who's interested in those two components to go back and rewatch those videos. They're accessible. But we heard y'all's feedback from the last presentation and that you wanted a deeper dive into the last will and testament. So we made the fun video that you saw at the beginning to kind of root out some myths and sort of talk about why estate planning is really important and how that last will and testament can really make your family's life better. The other two pieces of the complete estate plan is that it includes nominating guardians or conservators. This is for minor children or incapacitated adults if you're caring for somebody, and also information about trusts. So again, who needs an estate plan? At the Georgia Heirs Property Law Center, we really feel like it's imperative that everyone have an estate plan. At the bottom line for us is increasing generational wealth, and the transfer of that generational wealth is done through a well-written, well-crafted estate plan. So again, it preserves the value of your asset and ensures that the right person is making decisions for you if you become incapacitated. So last will and testaments. Let's start with, what is a will? So essentially a will just leaves instructions for what's going to happen to your assets, also minor children or incapacitated adults when you pass away. And there are four major functions of this document. It allows you to give your assets to other people upon your death, allows you to appoint an executor to oversee your estate. So in the video you heard, I can't remember all the characters' names, but the older brother was irritated that he had not been named as executor in his father's will, but his father was choosing an executor who he felt could best oversee the business aspects of, dividing out the assets. Then it also allows you to establish a testamentary trust and appoint a trustee to hold and protect assets if you have minor children or are caring for an incapacitated adult. And you can appoint a guardian or conservator to protect the interests of minor children and incapacitated adults. So we recommend that you always work with a trustworthy licensed attorney to prepare your will. Yes, there are online forms, but your unique circumstances might not fit into the pre-written boxes, and you really want to be able to work with somebody, hopefully, that can help you think through some of the bigger questions. So why do you need a will? You know, the big picture items is that, you know, it ensures that your wishes are carried out exactly as you would like to have them carried out by the person you have chosen to be the executor of your estate. It allows you the opportunity to leave property in a way that doesn't create heirs property, which we have lots of reasons why creating heirs property makes things more difficult for your children and grandchildren. It allows you to choose someone trustworthy to care for minor children. In general, it protects the financial interest of your family, especially surviving spouses or minor children. It allows the testator's family, which is you, to be part of the decision-making process as the will is being prepared. So you can include, you know, discussions with your family members while you're making the will, if you wish. And most importantly, it allows your family time to grieve, you know, without having to immediately begin arguing with each other and with attorneys over what you would have really wanted to have happen, because you will have written it out for them. So, you know, at the center, we really recommend, even if you own a fractional interest in a piece of property. So let's say, you know, you have a family home, you know, it's been passed down from mom said it was going to go to your older sister, but mom didn't have a will, which technically means that you have an ownership interest in this home. It's a good idea, even if the property is still in this tangled title situation, to go ahead and pass your fractional interest on through your estate plan to, we have a couple of different ways to do it, but in a way that doesn't continue to compound the problem as it divides out amongst heirs. So again, don't wait until the heirs property is resolved to begin engaging in your own estate plan. So let's do the next one. All right, here are some of these important terms used in a will, just to give you some information so that when you go into the process, you know what is being spoken about. Decedent would be the person who's passed away. Estate is all of the real property and possessions belonging to the decedent. Beneficiaries, those are the people who receive a benefit under the will. There's a lineal descendant of a beneficiary, so this includes children, biological or adopted, but not the spouse. The executor is the person named in the will to handle the administration of the estate. And per stirpes is the distribution of the estate when a beneficiary dies before a decedent. So this is like, if you've created a will, or if I've created a will and I've left my home to one of my children, but that child in particular predeceases me, passes away before I pass away, that child's share is then distributed amongst the other descendants in equal shares. All right, assets that can and cannot be distributed through a will. So most of your assets you can distribute through a will. So things like your home or land, vehicles, personal property like jewelry or furniture, and then money that is in bank accounts or investment accounts. But there are some things that you can't put into a will. So you can't distribute a home or other real estate that belongs to a bunch of siblings. So you can't just say, well, I'm going to leave the entire timber tract to my children through my will, if technically you own the timber tract with your siblings. Joint bank accounts. something where another person is on the name and you don't have full right to leave it to somebody else through your estate plan. And then assets held in a living trust. And then there are a couple of items of things that you shouldn't put into a will. So things like life insurance or retirement accounts, pension plans, or 401ks. In those situations, you get to designate a beneficiary in the documents that you have that set up your life insurance policy or the 401k. And that's where you would designate who those assets go to. So, execution requirements for a valid will. This is one of those questions that we get asked about quite frequently. I think the uncle in the video sort of said, well, can I just write down my wishes and then mail them to myself through the post office, and that counts as a will? We've had folks, write up a will and then protect it by putting it, tucking it away in a safe space. However, if you don't go through the process of, executing a will legally, it won't stand up in court. It won't be seen by the probate court as a legitimate will. So to be valid, a will must be a written document. So it can't be, Uncle so-and-so said that I was going to get the house. So it has to be a written document. It has to be freely and voluntarily signed by the testator, the person who wrote, whose will it belongs to. It has to be signed in the presence of two disinterested witnesses. So this doesn't mean two people who don't care what's going on. It means two people who are not beneficiaries of the will. Ideally, people who are unrelated to the situation. So two disinterested witnesses. And then of course the will has to state that the assets discussed in the will are transferred upon the testator's death. There's actually no particular form or words that are necessary as long as the document makes your wishes and intentions very clear. Again, Georgia does not recognize an oral or an unwitnessed will. And there's another piece to the will that we call a self-proving affidavit. And that, in addition, has the witnesses and has a notary, which can be really, really helpful in making sure that there's no hiccups. When your will is taken to the probate court, it will be accepted and hopefully move through the process quickly so that your heirs can get the assets that are discussed in it. So again, it's important that you have a will that's properly witnessed and that you have a properly witnessed and notarized self-proving affidavit. Okay. So last wills and testaments may change over time. We at the center recommend, honestly, that you review your last will and testament annually, and that you absolutely update it as circumstances change in your family. So if there's a birth of a new grandchild, or there's a death of a family member, especially somebody who was named as a beneficiary in the will, if you go through a divorce, if there's a severe illness, something incapacitating, or changes in the community and the economy. But this is incredibly important. You should never, never, never change your will by writing on your will. We've seen situations where there's whiteout on a legal document, or there's something is crossed out and they try to initial it. However, the reality is writing on a will void the document. Again, that goes back to the will has to be signed in the presence of two disinterested witnesses, and then have that notary on the self-proving affidavit. So it's sort of a document that all has to be executed at one point in time, and you can't go back and make edits on it. So there's a couple of ways that you can update a will, either a new will can be prepared, or potentially there's something called a codicil, which is a additional piece of information that gets added to the original will, but it goes through a process of being witnessed all over again. Safeguarding your documents. We spend a lot of time talking with folks about safeguarding their documents. You know, maybe putting it in the freezer is not the best place, but it might be the best place. So essentially, what's really important about this last will and testament, you want to put that original document that with the witnesses' signatures and notary in a very safe and accessible place. So don't stick it in your safety deposit box that nobody has access to. And you really want to make sure that the executor, the person that you've named to be in charge of handling the estate after you've passed away, knows where your original copy is. So Georgia has 159 counties, and each county has a probate court. Each probate court has slightly different rules, like one you might have to fill out a form, another charges, you know, like $15 or $25, but you could actually have your original will on file at your probate court if you'd like to keep it there for safekeeping. But again, don't write on it, don't cross anything out. Doing so might make it invalid. So that's sort of the first part. Now for questions, I know we've been getting lots of questions in the chat. I'm not sure, Skipper or Wanda, if you want to read it.
We have been talking to some folks in the chat. It seems like the presentation might have answered one person's question, and Wanda was checking to see if folks wanted to ask their questions out loud or if they wanted us to ask questions for them. And was there any response, Wanda, from your asking folks? No one has responded, so we'll just go down the list. There's a question about whether or not there's any online website where we can get our papers done. I'm assuming that when you refer to our papers, you're meaning your estate plan. I actually, I don't know of any website, and I wouldn't recommend that you use a website because oftentimes there are nuances to estate plans that should be discussed with an attorney. I am aware that there's a limit of access to estate attorneys, which is something we're trying to work on with the center. And if you want to reach out to us, we can see what we can do about setting you up with an attorney to do your estate plan. We may not be able to do that, but you're always welcome to contact us. There was a question about can all the landowners make a separate will together that may be more defined from the original will? So I believe that the challenge with that question is that you're combining two concepts. The landowners each have their own right to the land, meaning like with heirs properties and tenants in common, but they don't all write the same will, and there's no original, you can't rewrite a will from a predeceased family member. So the wills are very separate from the wills of living people now are very separate from the land ownership structure. Again, if you would want some more information and sort of untease what you're trying to get to, please feel free to submit some more questions. There was another question about what is the fee structure for estate attorneys? In other words, how is the lawyer paid upon the death of the testator? The estate plans are paid up front when you when the attorney prepares the last will and testament, and also the financial power of attorney and the directive health care. It is not when someone passes away, there are additional cost entailed, which is like probating the will and doing other steps, but estate planning is paid up front. Let's see, what's another question? Someone asked if you could, if we could provide more information on a living trust, and I'm taking that terminology to mean more information on setting up a trust while you're alive. We are actually not covering that in this webinar. We're talking about specifically estate planning and last will and testaments. So if you would like to seek more information, you're welcome to go to our website. And our website will be posted. The questions are coming in very fast now. Hold on a second. Our website will be posted at the end of the program, and also I will post it to everyone in chat in a minute. There's a question about, would an oral will and a video will be considered the same from a legal standpoint? Your will has to be in writing. An oral will or a video is not actually going to stand up to Georgia law. And there's a question, which is a very good question. And let me say that y'all are welcome to ask your questions and we can unmute you. If you would like to be unmuted to ask your question, you can simply type in the chat, please unmute me. And the next time we have a moment where there are questions, we'll unmute you. What is a self-proving document? So a self-proving document is added. Did you go over this, Delene? Or did you touch on it, or by starting from scratch?
No, I touched on it, but just barely.
Okay, so you have the last will and testament, which is only required legally to be signed by two disinterested witnesses that are, but there's no requirement that the last will and testament be signed by a notary. Sort of the gold stamp seal on a will is to have an affidavit that is actually signed by two witnesses, and a notary is just a one-page document that verifies that that is actually your will. And so it's just sort of takes it another step. So it makes, ideally, it makes the estate process through the probate court easier. Let's see. This is a really good one and is very much something that we talk about a lot in our myths and facts and in our heirs property webinar, which you can also find on our website. If a husband dies without a will, does the wife automatically receive the estate if there are no minor children? If there are any, if the husband died, if any spouse, husband or wife, dies without a will, and there is a spouse and children, no matter what their age, minor or majority, the wife, the spouse, and the children split it. It is a myth that the spouse will inherit all of the property. It actually doesn't work that way. We have a lot of information on our website about the intestate process and how the state defines how folks inherit property. Let's see. What are potential delays in settling estates? You name it, the gamut. There are so many possibilities. Oftentimes, if you have the right, if you've taken the initiative to have a last will and testament, you have a self-proving document, self-proving affidavit, it can go through rather smoothly. But that is something we're working on, is helping folks understand the importance. I'm laughing at this next question that I just read, but the importance of good estate planning. What would be a criteria or characteristics to select the perfect child / heir to administer your estate? That's a very challenging question. That's, it takes certainly a business mind. It takes someone who is equitable and fair. That is a challenge. Oftentimes we see folks ask people who are not their children to administer the estate. But That's something that you're going to have to talk through with your children, and that's a hard and complicated decision. Is it better to put child name on home deed or put it in a will? That is really dependent on the situation. That is dependent on the situation, and you don't want to accidentally create heirs property by putting, if you put your child's name on the deed. So there are a lot of consequences. If you put your child's name on the deed and your name's still on there and you have other heirs, then if you pass away, you run the risk of the child having inherited the property with a whole bunch of other people. The other situation is that there's federal tax consequences, and I'm not a tax attorney, so I'm not going to go into depth about that. But there are reasons why you may want to do it beforehand or at the time of your death. And so that becomes a little bit more complicated, and sort of depends on the situation in order to give you the best answer for that. There's also a form which we don't advocate for very often because it gets complicated, where you can retain a life estate and convey your property to your child while you're still alive. So there are several different options. It's best to talk to an attorney and really spell out your particular situation. Where can we find the recording for this? I'm going to pause there. There are more questions coming in, but let Delene or whoever speaks next explain where the recording will be.
So as soon as we get the recording, we will attach it to, there's a couple of different Facebook pages, I think Fort Valley, the center, and we will be able to send a link out to everyone who has registered for this. So you'll be able to view this presentation again or share it with others. Okay, I'll turn it over to Gentry now.
All right, so what happens when someone dies with or without a will? I'll go through both scenarios. If somebody dies with a valid will, that's called dying intestate. When you die testate, you decide who inherits from your estate because your will says. You decide who becomes the executor because your will says that. You get to decide who becomes a guardian of your minor children or an incapacitated adult heir. If you leave your property in your will to more than one person, you are still creating heirs property. And this will then must go through the probate court process to have effect. So just because you have a will in hand, it doesn't have any power, and the executor doesn't have any power until the probate court confirms that that is a valid will and appoints the executor and gives them what's called letters testamentary. That's the actual power that the executor needs to administer your estate and give out your property. If you die without a will, you have died intestate. When you die intestate, the code, the Georgia code, dictates who inherits your property. A probate judge decides who should become the administrator. Multiple people have the right to be the administrator, but if multiple people attempt to be the administrator, it's up to the probate court, probate judge to determine who's more fit. A judge will decide who the best person is to be the guardian of your minor children or an incapacitated adult heir. And if you own real property and have more than one heir, you have definitely created heirs property. When you die without a will, you, in order for your property to pass, you still need to go through the probate court process, but it looks a little different than when you have a will. Instead of asking the court to confirm that the will is valid and appoint the nominated person, you're going to apply for letters of administration, and an administrator is appointed who will manage your affairs. Why is dying intestate a problem? It's because the code decides who inherits your property, and that might not be the same as who you would have chosen. Perhaps you have a child that has more need than others, or you want one child to get your home and a sibling to get your money. The code doesn't take any of that into consideration, so you lose your chance to make the choice yourself. Your assets are also divided equally. Like I mentioned, maybe somebody needs what you have more than somebody else. Intestate succession could create an increased risk of family discord and disputes. Things often get a little wonky when somebody passes away, but if you just told people what you wanted and didn't write it down, that doesn't have any effect, and it often causes one child to say, well, mom was going to give me this, or mom said I got that. And so it's really best to just write it down, and even better to also speak with your heirs before you pass away and make sure they hear it from your mouth that that's what they wanted, that's what you wanted, rather than waiting till you die and being like, what, mom didn't give me this? And then instead of getting mad at the deceased parent, they usually get mad at their siblings, and just it creates a lot of heartache. And also, as we've talked about over and over again, when real property is inherited by multiple people, you have heirs property. So we want to avoid that if possible. So how property passes when you pass away without a will, it's complicated. And what we have here is from the code, and I'm just going to run through it quickly. It's a whole nother topic probably, but if you are married and have no children, your spouse gets everything. If you're married and have children, the property is divided between your spouse and your children. The proportions change depending on how many children you have. If you have children but no spouse, then your children divide everything equally. If any of your children have passed away before you, then their children, if any, inherit their portion. If you do not have a spouse, children, or grandchildren, your property goes to your parents equally if they are living. If they are not living, then it would go to your brothers and sisters. If any of your brothers or sisters have passed away before you, then their children, your nieces or nephews, would take their portion. Okay. If you have no surviving brothers and sisters, it goes to your niece and nephews to share equally. If you don't have siblings, nieces, nephews, parents, or closer relatives, then it goes up to your grandparents, which you likely don't have at that point if you don't have any of the others. And then from there, it would then go to your aunts and uncles, and then to your cousins. And if you have no surviving relatives at all, your property becomes, it's called escheats to the state of Georgia. Probating an estate. So as I mentioned, probate is the process of proving a will is valid, appointing a personal representative, either an executor if you died with a will, or an administrator if you died without. Their job is to represent the estate. So they collect the assets, they secure them, make sure they're safe, they pay any debts that there may be, and then distribute the assets to either the beneficiaries under your will or to your heirs if you did not have a will. So if there's a will, you should file that will and the appropriate petition in the probate court in the county where the decedent lives. Again, a will must be probated before it actually can transfer title to any property. If there's not a will, you still need to file a petition with the probate court, but there's various options. And so it's best to have an attorney help you along the way. So how can you prevent heirs property through estate planning? During your lifetime, you can change the title to the property while you're living. One way it's popular for spouses is to own real property as joint tenants with right of survivorship. This is when the deed has very specific language in the deed, and it says as joint tenants with right of survivorship. This way of owning property didn't exist in Georgia until 1977. So if you and your spouse have a will from before that, you own the property as joint tenants. You own the property as tenants in common. And when you own property as tenants in common, so let's say husband and wife each share it together, when one of them passes, their 50% goes to the spouse and other heirs. And so the spouse does not wind up with 100% unless there's no kids. And so if you can get your deed changed to a joint tenancy with right of survivorship, then that real property does pass entirely to the other person on the deed, the other joint tenant. So it's a really popular way for married couples to own property. And so it prevents heirs property when the first joint tenant passes away. When the second joint tenant passes away, if they don't have a plan in place, it could still go to multiple heirs. Tenancy in common is the default. So if you bought property and didn't tell the attorney that you wanted it deeded to you and your spouse or your sibling as joint tenant with right of survivorship, it went as tenants in common. The other thing you can do while you're still living is to put property into a limited liability company or a trust. This is usually more appropriate with larger or income generating properties. The owner can still manage or control it until their death. Things you need to take into consideration is whether putting property into an LLC or trust jeopardizes your homestead exemption or other benefits, or would impact your mortgage, your security deed, whether it might impact your property conservation status or grants and other funding. So you just need to, that's something that your attorney needs to take into consideration when they're helping you convey that property into an LLC or a trust. And then ways to prevent heirs property through your last will and testament. The simplest way is to just leave it to a single family member. This can often be a hard sell for people who have multiple children to pick one child over another. But what we recommend is that you speak to your children and see if they actually want it. People assume that all their family wants to keep the property, and choosing between them might hurt feelings or cause animosity. So it's worth asking them. You might be surprised to find out that one wants it and the others don't. And that opens you up to designing an estate plan that satisfies everybody's needs and wants. You also have the option to leave the property to a nonprofit, a land trust, a house of worship, or another organization. The second option is to leave the property, to bequest it into a testamentary trust. So a testamentary trust is just a trust that is created within the language of a will. And so this is, as opposed to putting the property into a trust before you die, which would be either a revocable or an irrevocable trust, a testamentary trust does not come into effect until after you die, after your will is probated, and the executor sets up that trust and puts a trustee in place. So title to the property would be vested in the trustee of that trust, who manages it for the benefit of the of the trust beneficiaries, which are laid out in the will. A trust can continue almost indefinitely. In Georgia, it's 360 years. We think it's better to create a trust within the language of the will rather than having a paragraph that says the executor should create a trust. This means that title goes straight to the trustee. It's never held by the heirs, and you get to control the terms of the trust. You set them up in your will before you pass away, rather than saying, hey, executor, come up with the rules of engagement for this trust, or it's called a trust agreement. A will should include language about how the income of that trust and the principal should be distributed, under what circumstances can real property be sold, how taxes and other expenses are paid, who's responsible for them, and what happens to somebody's interest in that trust when he or she dies. The third option is that for bigger pieces of property is that the executor physically divides the property between family members. So ideally, this would be as equitable as possible. It's only going to work with property that can be divided into parcels that are approved by the county. So counties have zoning regulations about how small a parcel can be. So if there's too many people and not enough land, it's not going to fly with the county zoning office. We recommend that if you go this route, you don't just say, hey, executor, split it up however you like. The ideal situation is that you get a survey before you pass away and you specify who gets exactly which portion. Option 4, you can sell the property to family members or others. So you can leave instructions for your executor to sell it. You can give them the explicit power to sell that property. The price is up to them. They do not need the court's approval. They do not need the heirs on board. You could also give your family members the option to purchase it, like a right of first refusal, or lay out instructions for how one child could opt to buy out the other children's interests. If none of the family members are able or interested, then you could give the executor the power to sell it to a third party. It's important that those instructions say who has the option to purchase and how the price will be determined. Are you gonna, do you get an appraisal? Do your children make offers that have to then be approved? And you want to make sure that by giving this option, you're not just complicating the relationships of your heirs. And if you're just going to sell the property, your will needs to give instructions about who's going to receive the proceeds and in what proportions. Ultimately, it's your choice. We counsel clients against creating heirs property, but if that's what you want to do, it is your choice. You just need to take into consideration that real property is often the most valuable source of generational wealth for families. I've been doing estate planning for almost 6 years, and I have found that for most people, their most valuable asset is their home. And that goes for people up and down the socioeconomic scale. So it's really important that you leave all that money that you have wrapped up in your home to your children in a way that they can access it. And now we can take some more questions.
Hey, okay, so we're ready for some questions, and I've got to, okay, I think I have that corrected. Okay, so we're ready for some more questions. And I do have a few already. Someone asked if they could, I think basically what they were asking was if they could disinherit their either like son or daughter-in-law, so that their child would inherit whatever property they leave to them, but the person that they're married to would not be able to inherit it. And yes, you can do that. you can word your will in such a way that the spouse would not be able to inherit that property, but you would really need to talk to an attorney about that and make sure, you know, that the language is correct, so that you can make that happen. Another question we had was essentially, can an executor of a will share the duties of administering the estate with another person if it's I guess if it's difficult for them to take care of it on their own, if it's a hardship. Legally, if only one person is named as the executor, then that's the only person that can legally do anything. You know, maybe could informally delegate something to someone else, but from a legal standpoint, it's that executor's name that is on everything and has to be basically in charge of everything and is the final responsibility.
However, an executor can step down and decline the position. That's all I was going to add. If it's a hardship for them, they don't have to do it. That's a moral and emotional decision, but there's no, you know, you can always step down. So I'm going to turn it back over to you,
Skipper,
Wanda.
would you explain what happens if an executor does step down and do that? Then what would be
If there are other executors in line behind that one, like oftentimes a will say, you know, the first, you know, this person, and if that person has predeceased or can't serve, then it would be a successor executor or executrix, and it would go down the line. If no executor is in line to serve and someone steps down, then it would go through a court process of appointing someone. Okay, Wanda, all yours.
All right. It looks like I just have one more question. And it was from our Facebook feed that how would the interest be divided basically between a surviving spouse and 2 children when the other spouse is intestate? And correct me if I'm wrong, make sure I'm remembering this right, but the spouse would inherit 1/3 of the estate. And then if there are 2 children or ever how many other children, they would inherit 2/3, and that would be divided between them. So in the situation where there's 2 kids, each one would get a half of 2/3. So 1/3 each. And that
I do see that one person has their hand raised.
okay.
Um,
Oh, I see it now. Okay.
so Brendia, would you like to unmute yourself and ask your question?
Yes, thank you. I put it in the chat, but I guess it was, didn't anybody see it? But anyway, I wanted to ask, if there are 3 sets of children and the person dies without a will, and everybody wants to sell except 2 of the people, is there a way to force them to sell it? Or do we just have to, would you just have to keep waiting? Thank you.
Ms. King, I actually answered you directly and explained that this was outside of the scope of this presentation today. We are focused on last will and testaments, and your question is rather complex, and that it deals directly with heirs property, and without engaging and looking through the situation, we can't directly answer that, because we would have to know the circumstances of trying to force the sale. And there are several different legal strategies that could be applied. So I apologize, but we're going to have to decline that question at this time. And it looks like Ms. Smith has her. Sure. Ms. Smith has her hand raised.
I do. Can you hear me?
I can.
Okay, what happens when an executor refuses to give information to the other brothers and sisters? Just refuses. Can you force that executor in court to give them information about the will and about what's going to what person?
So there is a mechanism where you can request an accounting through the court. And I am sort of, Gentry, do you want to speak to this?
So it depends on the circumstances. It depends on the power that that executor was given from the court and given in the will. Sometimes the executor does not have to file reports and an inventory with the court, and it does not have to give it to the beneficiaries. Most wills would say that you have a right to request an inventory, and so you can do that through the court.
So you could be cheated and not even know it.
If the will said that they did not have to report, and the court gives the executor, waives the requirement that the executor reports, then yes, in theory you could.
That's not sounding good. That does not sound
so
good.
The will specifically has to grant them that power, so you need to go back and look at the will.
Okay.
But you always have a right. You always have a right to check in. Okay.
A right to request, in other words. Okay.
Okay, I think that's all the hands we have raised, but we have some questions coming in. And let's see, hold on just a second.
I see this last question is a good one.
Oh yeah, that's the one I saw. You want to take it, Wanda?
Sure. What happens if a wife entered a marriage with children already and the husband and wife don't have any children together? Does the husband still inherit one third of the real property? And the short answer is yes, he does. He certainly does. Her children from the previous marriage would also inherit, but he's the spouse, so he wouldn't inherit if there is no will.
Okay, and there was another question about how to find a good attorney and what is the average amount charged. That's a little dicey. I don't know the average amount for Georgia, but I will say that 70% of the attorneys in the state of Georgia are in Atlanta, which is part of the reason we're doing the outreach that we're doing in rural Georgia. You are welcome to contact the center to see if you would qualify for our estate planning program. And if you would not, we would do our best to try and find an attorney in your neck of the woods that would be able to help you. No promises, but we're committed to this and trying to make sure that folks get the services they need for estate planning, especially during this pandemic. It looks like Ms. Maddox has put up a survey, so please take a moment and fill it out if you would like. And then there is a question that I'm actually going to ask Gentry to answer, just because I feel like the longer this goes on, the less brainwaves I have. And that is, can you petition to have an uncooperative co-executor removed as an administrator?
So I mean, you can petition to have an executor removed, so I suppose you can ask the court to have a co-executor removed, and it would be up to the judge.
So there's another question, will forming an LLC void out heirs property laws? It depends on how the LLC is created. And if you get all the heirs to convey their property into the LLC, then yes, it would. And we have used that tool for some resolution for some of the cases that we've handled in resolving heirs property. Any other questions?
I received a question directly that says, suppose there are two co-executors and one doesn't cooperate with administration of the will. Can you petition to have the uncooperative executor removed? And that would kind of fall under the same. Oh, okay. So she asked it twice. Sorry.
No worries.
I see it
Never
now.
hurts to hear something more than once. So any other questions? I believe the next slide hopefully is actually our website and contact information. Oh,
We have a
we
few.
still have more information. I'm sorry. Keep going, guys.
Excellent. Okay, so I will fly through this part because I want to make sure that everybody gets out on time. It's just a little bit of information about what decisions you probably need to make before you go and visit with an attorney to prepare a will. So, essentially there's no set language that's required in a will, but there are some, there's a couple of things. There are statutory advance directive for healthcare and statutory financial power of attorney forms. So it's recommended that you can go ahead and download those off the internet for Georgia statutory advance directive for healthcare. But let's go over to the standard provisions in a will. So typically a will is going to identify a spouse, names of children, what you would like to have done with your remains, instructions for dealing with debts and expenses, how you want land or your home distributed, the various ways Gentry just mentioned, instructions for any other personal possessions, including cars, but also stocks, bonds, and other assets. It identifies who your executor is going to be and what powers they're going to have. So you could write in your will that you want the executor to not have to report anything to anybody, but that's probably not a good idea. You can create a trust, and then you can identify the guardians for minor children or incapacitated adults. So a couple of major decisions that you're going to need to think through is decision number one is a decision about your remains. So if you already know whether you would desire burial or cremation, also state where you wish to be buried, or what you want to be done with the ashes if you have a very particular location. You could leave that up to the executor or your heirs, but you can also be very specific about it in your will. And then again, know that your will might not be fully read until after the funeral has already happened. So with your remains, you should probably let people know your wishes before you pass away, while you're still alive. Decision number two, your executor. I know there was a question about identifying the perfect child, and I appreciated that Skipper mentioned many people don't choose a child to be the executor. They have a trusted family friend or other professional that they have discussed it previously with and chosen, because you want this person to be someone who will actually carry out your instructions. You want them to be honest, trustworthy, responsible. A lot of it is like the minutia of business stuff, like handling bills and needing to be professional. They can be a spouse, a family member, a friend, a lawyer, financial institution, usually for a fee, and they don't need to live in Georgia. So co-executors, we don't typically recommend co-executors because it can slow down the process of distributing your assets and, actually making your wishes actualized. but you can always do co-executors. And as mentioned before, there's successive, so you can name somebody in your will as the executor, and then also name, if that person can't serve, you want this person, and if that person can't serve, you want this person. So you have some layers. And it's always good to ask them if they're willing to serve as executor before you pass away. And you want to have 1 or 2 backups. Decision number 3 is about who will receive your assets. Your home or your land, personal property, bank accounts. We highly recommend an option that does not create heirs property. And then rather than listing all of your, like, I leave the figurine of the little cat to so-and-so, and I leave the mirror with the, wooden frame to so-and-so. You can consider clipping a list, a tangible personal property list to your will that you can make edits to over time. Like a new grandchild shows up and now you want them to have the little figurine of the cat. So keeping it separate, your will can say, I'm going to leave informal instructions for how I'd like my personal property distributed. So it doesn't have to all go in the will. Decision 4, you need to think about whether or not you need a trust to support grandchildren or children or grandchildren or other family members who are under the age of 18 or incapacitated. For those kinds of things, you'll need to figure out who you're going to have the trustee be. They need to hold the assets until the beneficiary reaches of age and manage those. You can also establish a family trust through your will, which then can provide general directions on how the trust should be managed and handled. Decision 5, your trustee, if you need a trust, again, similar to the executor, they need to be trustworthy, honest, responsible. You need to select some backup trustees. And a trustee may serve in that role for quite a bit longer than an executor. I mean, in a perfect world, the executor executes the wishes in your will and wraps it up and is done. But a trustee who's responsible for managing assets on behalf of your family may be in that role for a lot longer. So maybe don't pick, your 95-year-old uncle for that role. Decision 6, reports and bonds. So you have to file reports and inventories. This is what, Gentry and Wanda and Skipper were mentioning earlier. The executor is technically supposed to file reports and inventories with the probate court. And sometimes Georgia also requires that the executor post a bond, which is a type of insurance to protect the estate from theft or mismanagement, unless you state in your will that that's not necessary. Reports and bonds provide extra protection against a dishonest executor, or, like if a squabble breaks out between siblings, reports are always a good thing to include. And then, of course, we always recommend start by having conversations with your family. Let them know what your wishes are. Gauge whether they're on board with your legacy or sort of how you want things to be left to them, and then get their feedback. I mean, it's important to have your wishes respected and honored, but it's also important to hear what they're telling you about what they hope for their futures as well. And it can be a really powerful, important conversation to have with your family members. So again, having a will doesn't mean that you have not created heirs property, but having a will that doesn't leave that property to more than one person is the best way to prevent heirs property. And again, we recommend that everyone have an estate plan done. So resources. Again, the center on our website, we have tons of resources. We have a PDF, Georgia Estate Planning Handbook for Communities that you can download and read through. We have myths and facts about heirs property, and if I pay all the taxes, does that mean I have a greater ownership share in the home? No, it doesn't. We have links to webinars, and then we work a lot with communities. So if any of you are in a community that you feel could really benefit from some title clearing services or estate planning, we do a lot of educational outreach with community leaders, whether they're elected, the mayor and commissioners, county commissioners, or neighborhood leaders. And we assess the condition of titles and then hopefully provide some title clearing and estate planning services. So the last slide has our website, gaairsproperty.org, has contact information, our general line, and info@gaairsproperty.org. Again, those publications, PDFs and stuff are located in the publication folder.
I'm going to interrupt if I can.
Yeah,
We
yes.
do have one question and we just have 3 minutes. So
Go for it.
let me answer this question. The question is, who can use the Georgia statutory of power of attorney? Do they have to reside in Georgia? Ideally, they would reside in Georgia. Whether or not they could use it for other states or out of country would be dependent on the laws of those states in that country. And we can't provide legal representation outside of the state of Georgia. So I don't actually have an answer for you on whether or not you can use it outside of the state of Georgia. We do not have other links to other states' heirs property on our website. We are very Georgia specific because that's the area that we serve. Any other questions?
While Skipper's looking for other questions, again, we want to say thank you to Fort Valley Cooperative Extension and UGA Extension. This is a really wonderful project and really important information. Again, we would love it if you would please fill out the evaluation form. It helps us figure out exactly what kind of presentation you would like from us next. So yes, Brenda has put the survey link in the chat, and hopefully you'll take a few moments to fill that out.
So with that, if there aren't any other questions, and I don't see any raised hands, again, thank you to our partners, Fort Valley Cooperative Extension and University of Georgia Cooperative Extension. And with that, I think we'll call it a
Those
day.
links, Skipper, let me interrupt you
Okay.
just a moment. The link also for the Fort Valley YouTube page, as well as the Ag Facebook page, where they can find copies of the video as well, once editing has been done. And I believe also we sent them to everyone that registered, as Deline mentioned earlier. So those are in the chat as well, those Facebook pages.